Hello and welcome to our webinar in relation to Brexit and what employers should know about their EU national workforce once we leave the European Union and beyond. My name is Ilda. I'm a partner in the immigration team at Kingsley Napley with my colleague Corinne Elliott, a solicitor in our immigration team. And together we aim to give you a very brief overview, hopefully not more than 30 minutes, outlining the things that we think you should know as HR managers addressing your European national workforce. Before I proceed, I do want to thank Brian and Sue from Citrus Relocation for giving us the opportunity to work with them and to present this webinar to their clients. So, as part of the overview that we aim to discuss with you today, I will give you an overview of Brexit and where we are currently on the 6th of February 2018. I also intend to give you an overview of what European citizens currently can do in the UK under European law and whilst we're still members of the European Union. My colleague Corinne will then talk to you about what are the rights of EU citizens entering the UK after the Brexit date, and that will include the period of transition and beyond. I will also end by covering the outstanding issues, which really will be the issues relating to the transition period and also beyond, and then finish off by some advice that we think you should be following in terms of what you should be doing with your EU workers currently in the UK. So, in terms of the Brexit timeline, if you can cast your mind back to the 23rd of June 2016, when the then Prime Minister David Cameron called a referendum with the question that was very simply put, do we want to stay in the European Union or do we want to leave? The result was then made public on the 24th of June 2016 with a 48-52% margin in favour of leaving the European Union. The Prime Minister then resigned. There was a new Prime Minister appointed, Theresa May, who's still the current Prime Minister. And on the 17th of January 2017, she then makes what I would call the famous Lancaster House speech, where she outlines the vision of what the government would like to see in relation to Brexit. On the 29th of March 2017, Article 50 of the Lisbon Treaty is triggered. This is the legal mechanism that allowed us to give the European Union notice of our intention to leave the European Union. Now, for those of you who did follow this, this was quite a famous and a hot topic at the time, because the question was whether or not Article 50 should be triggered after following an Act of Parliament or through a very famous royal prerogative, which would mean that the Houses of Parliament wouldn't necessarily need to pass any form of formal legislation. This went all the way to the Supreme Court of Appeal, and it was found that it had to be triggered by way of an Act of Parliament. The legislation through the Lisbon Treaty, Article 50, actually states that we have and give 2 years of notice within which to leave the European Union, but it also allows us to extend beyond that period if, of course, we can get all member states to agree. At the moment, it does seem, though, as if we will leave in March of 2019. On the 8th of June last year, Theresa May then calls a general election, does not win by the landslide that she thought, but nonetheless wins, and then starts phase one of the Brexit negotiations, where she currently concluded three topics. The first was the rights of EU citizens in the UK and that of British nationals in other EU member states, the financial settlement, so-called divorce bill, and then of course the issue relating to the Irish border. For those of you again who have followed this, phase one, which covered these 3 points, was actually finalised on the 8th of December of this year. And as we speak, the UK is currently negotiating phase two of the period, which now covers the transition period. And again, also the trade, which will follow after we've discussed the transition period. Now, as I said before, Under the Lisbon Treaty, the period is a 2-year negotiation or a notice period. However, as we've now seen, the European Union have already made clear that as part of the transition, their stance is that the negotiation or the transition period should end at the end of December 2020 and not a 2-year period as ideally the UK government will want. So what are the rights of EU citizens that they enjoy currently whilst we are still members of the European Union? There are currently 28 countries within the European Union, and the UK being one of them. Alongside, there are also countries within the European Economic Area and Swiss nationals, so Norway, Liechtenstein and Iceland, not members of the EU, but all these nationals enjoy and are treated as if they are EU nationals, which give them the full right of free movement across the European Union. This includes the United Kingdom. This allows them the right of entry into our country and an initial right of residence for up to 3 months, where essentially there's no requirement on them to work or indeed take up any form of studies. They can literally stay without doing anything. At the end of a 3-month period under EU law, EU nationals will be expected to become what we would refer to as a qualified person under European law. So, for example, they can work free without any restrictions. The only restrictions currently in place is for Croatian nationals, where, as you may have known, Croatia joined the EU in July of 2013, and the UK government has the right to opt out of giving Croatian nationals the full right to work in the UK, and this can be up to 7 years. So at the moment, Croatians don't necessarily have the full right to work unless they fall under an exemption. Everybody else has the full right to work, and they can literally work in our country without obtaining a work visa. They can also be self-employed, they could be job seekers, they could be self-sufficient, so typically maybe a stay-at-home parent where they rely on their partner for financial support, which is quite common, or being a student, perhaps undertaking a degree course at a university. I think what's key here is that the Home Office certainly at the moment take the view that if you're a qualified person and you are here on the basis of self-sufficiency, so maybe being a stay-at-home parent and your partner supporting you, or you're a student, that they would expect you to have some sort of comprehensive sickness insurance in order for them to be recognised as being a qualified person under the law of the European Union. Now, currently, the law says that you actually acquire permanent residence after residing and being a qualified person in the UK after a period of 5 years. Now, there's no requirement for you to actually apply to confirm your right of permanent residence. And indeed, we didn't see that many EU nationals actually apply to confirm their rights for permanent residence until Brexit actually happened once the referendum took place. Now, it is worth pointing out that under current law, EU nationals can apply to confirm their rights for permanent residence. The process is at the moment reasonably straightforward and the fee is only £65. But again, it's that you should be mindful that, again, once we leave the EU, this is after Brexit takes place, those rights under EU law will fall away. Of course, we'll have to wait and see what the transition period dictates. But as things stand, if the transition period doesn't cater for this, then of course your EU law rights will fall away once we leave. With this, I'm going to hand over to my colleague Corinne, who will then talk to you about, if you like, the 3 stages of people, EU nationals, and their rights depending on when they entered the UK.
Thank you, Ilda. The future rights of EU citizens in the UK is really split into 3 categories, which you'll see illustrated in the image, in this image taken from the UKVI website. As you can see, Category 1 relates to those who have been in the UK for at least 5 years before the 29th of March 2019. Category 2 references those who have entered the UK during the transition period, and Category 3 for those who enter the UK at the end of the transition period. After months of disagreement on the issue, the UK and the EU have finally agreed on the key principles of the post-Brexit position for EU citizens and their family members resident in the UK. The details still need to be filled in, and key information about the process EU citizens will have to follow will still need to be announced, but we do have the basic framework. EU nationals who have been living in the UK lawfully for the last 5 years will be able to apply for a new settled status. The settled status will replace the permanent residence application, allowing those who apply and are approved to stay indefinitely. It is expected to be a much simpler process than the permanent residence application at the moment, and the conditions attached to it are expected to be the same, or if not more generous. And by that, they make reference to the fact that currently you can lose your permanent residence status if you depart the UK for 2 years or more. And what they're proposing to do for the settled status is to increase that period to 5 years. It's also expected that EU citizens and their family members will have a transition period, as Ilda mentioned, and that is expected to be around to last until December 2020, during which they are able to apply for that settled status post-Brexit Day, or convert their permanent resident status into settled status. Although we would recommend applying sooner rather than later. We do expect a voluntary scheme to be released in autumn this year, allowing people to apply for the settled status. So our recommendation is apply sooner rather than later. The UKVI have said that the cost of an application will not exceed that of a British passport. At the moment, a British passport application is around £72, although we do expect that to be increased to around £85 in the very near future. Those with settled status will enjoy the same access as they currently do to things like healthcare, pensions and other benefits. And anyone who has applied for permanent residence already will be able to convert this into settled status for free. So they are prepared to waiver that cost for those who already have permanent residence. Of course, this is subject to identity verification, criminality and security checks and proof of their ongoing residence. It's also been agreed that Irish nationals will not be required to apply for settled status. So for EU citizens currently in the UK with less than 5 years, if they arrive before the 29th of March 2019 but haven't clocked up that 5-year period required for settled status before we leave the EU, they will be able to stay until they reach that 5-year mark. At that point, they'll be able to apply for the settled status to confirm their right to remain in the UK indefinitely, and the same goes for family members living with those EU nationals or those who joined them in the UK before the 29th of March 2019. There is a rather generous agreement also applied to Coast family members in that they are able to come to the UK to join their EU national family member after we exit the EU, as long as the EU national was in the UK before the 29th of March 2019 and as long as that relationship existed on or before the 29th of March 2019. On the date we leave the EU, the withdrawal bill will take legal effect. The bill is currently in the House of Lords at the moment and will effectively transpose EU law into domestic legislation. No agreement has been reached just yet on how EU citizens will enter the UK, and entry requirements are still also unknown on how they will do that once the transition period comes to an end. The Home Office intention is that there will be that implementation period, as previously mentioned, allowing them to live, work and study on a registration scheme. You may have noted recently the European Union have stated that they want the UK to allow free movement to continue throughout the transition period, and that they want the UK to continue paying into the Union. Although Theresa May has made it very clear that this is not what she wants, and will be fighting that point in the negotiations. What the process for this registration scheme will look like is still unknown, as is the process once the implementation period is over. Both points are yet to be agreed, and it is subject to negotiations. You may also recall back in summer of 2017, the Migration Advisory Committee sent out a call for evidence to employers and practitioners in the UK in relation to economic and social impacts of Britain's exit from the EU. Those responses are being reviewed, and the committee is expected to report back to the Home Office with their findings in September of this year. And the idea is that their findings will contribute to how the process is lined out in the future, although we believe the most likely outcome is that EU nationals will be subject to national law once that transition period comes to an end.
Thank you, Corinne. So, what are the options for EU citizens that are then currently in the UK? So, as Corinne said, it is a voluntary scheme that the Home Office intend to publish sometime in the autumn of this year. And once we have full details, we will again share them with you. And the cost, as we've been told, will be the cost of a British passport, or perhaps for free if you've already acquired and can show that you've acquired a permanent residence card. The other option is to apply for a Home Office document under European law, perhaps because you want to become British and you do meet the qualifying criteria for British nationality. So currently, if you do want to become British, the Home Office will expect that you can produce a document that can show that you've acquired permanent residence, and generally that's after showing that you have been a qualified person for a period of 5 years. Equally, if you haven't quite met the 5-year qualifying criteria, nothing stops you from applying for a registration certificate. Again, the fee here is £65, just like that of a permanent residence card. And if effectively this is just a document again to show that you are here as a qualified person, perhaps as a worker, maybe self-employed, as a student. What would our advice be for you as an employer? As I'm sure you probably have done already, you can then identify all of your EU workers currently in the UK. You could, if you have an immigration provider, if you don't have an immigration provider, check and point them in the direction of useful resources, the Home Office website. If you do have an immigration provider, perhaps working with them to arrange for presentations, maybe surgeries, where you can discuss with them on a case-by-case basis what their options are. We've done that with a lot of our clients and literally given advice on a very case-by-case basis, because some individuals as EU nationals do want to become British because they meet the qualifying criteria, but perhaps they can't because they know they may lose their current nationality. And generally we work with employers on that basis to advise on a case-by-case basis. Equally, keeping your policies under review. That could be your employment law policies, because again, how will that change during the Brexit period? Equally, things under data protection laws. As we know, the GDPR coming into force on the 25th of May. Again, how could that change possibly during Brexit, if at all? But also thinking about the implications for your business if there are future restrictions on recruiting of EU citizens. Corinne's already explained that it's still up for negotiation during the transition, what the rules would look like for EU nationals during that time. But equally, we'd have to wait for the Migration Advisory Committee to advise the government on what the immigration rules should look like for EU nationals that come post the transition period. If you didn't take part in the call for evidence last year when the Migration Advisory Committee actually asked for evidence that you thought would affect you and how you would like the rules changed, there's nothing that stops you from contacting your local MP, making them aware of your position, what you feel, but equally contacting the Migration Advisory Committee, putting forward your reasons as to why you think your business will suffer if you're not able to bring in your EU nationals in the way that you currently would expect them to do. We've now come to the end of our presentation. We hope that this presentation has been presented to you in a very succinct way. Of course, there are a lot of question marks at the moment because the second stage of the transition deal is currently being negotiated, and then of course after that will be the trade talks. But we hope that we've summarised for you the current position, where things stand. if you have any questions, feel free. Our contact details are on the slide. And of course, if there's any other follow-ups, we will either do a follow-up webinar or our news alerts. Thank you very much for your time, and this is the end of the presentation.